All right, so now this is the cool part, Mark, Raul, Janet, and Dana. We get to kind of sit back and watch all the folks that are logging in right now, and you guys are breaking records left and right. Within the first minute, you've already got 70 plus registered attendees signing in, 81. I usually start, my sales pitch around 75, but I want to see what kind of a record, what kind of a draw Dana Fox really is. He's doing it, 118. I got to say, maybe it's all about Janet today. 119.
Hey, can you guys hear me okay, by the way? I switched to my AirPods.
Yeah, like the paparazzi's lining up for me.
Yeah, we're at 100.
Can you hear me?
Mike Cortese is already on the chat line making fun of us. All right, folks.
Cortese.
If you don't know who I am, my name is Peter Hecht. I am one of the founding partners at Magna Legal Services. I'm coming to you live from the Magna News Studios, which is my office right here in Center City, Philadelphia. Which, by the way, if you didn't see in the news, we're heading back to another lockdown where they're shutting down the city. So who knows where I'll be broadcasting from next? But I'm happy to be here in my office in Philadelphia. And I just wanted to give a quick introduction before we got into today's webinar program. So if you don't know what Magna Legal Services does and provides, we're an end-to-end litigation consulting and support company. And yes, Dana, I'm giving a little bit of a commercial for Magna, but I promised Dana that I would tone down the cheese factor. So I just want to keep it professional and say this to everybody. We're out here in the virtual wildlands like you all are too. We're out there trying to, drum up the business. We can't come to your office and shake your hands. I can't take you out to lunch yet unless I'm out in some other parts of the country where things are relaxed. My salespeople can't just do the drop-ins and bring all the Magna swag to the office. So it's challenging. So we've really pivoted to this virtual space. I've suffered a little bit from the Zoom fatigue, but we're getting by because we're doing really interesting things like these interactive webinars where we're able to bring you all online with some really interesting panelists. Everybody here is going to be able to chat questions. Our moderator is going to be able to answer them. But getting back to what we do, so we pivoted in the virtual space. We're a worldwide depositions support company, right? So you need court reporters for your depositions, for your hearings, your arbitrations. You call us at Magna Legal Services. You're thinking, hey, the court reporters, they can't show up in the bricks and mortar environment. All of our court reporters, Raul, are virtually set up. So you don't have to worry about anybody coming to your office. We'll set it all up. We'll help you with presenting the exhibits. You want to do the gotcha moment and slam that exhibit in front of Dana's witness and say, what about this? We got you covered there. You need to do the call outs. We got you covered there. Virtual interpreters are available as well. It's pretty popular for us. And remote records collections. Dana, I know you every now and again you get a case with some injuries. You need to get those medical records collected. We've got you covered throughout the country. For those of you that don't know, we bought a little old company called Record Track, which has 40 years of experience and hundreds of thousands of facilities in the Rolodex. It's awesome, and they've got some great proprietary technology. We're making that available to everybody. Last but not least, and this is where Dana and I and Mark Calzaretta really got to know each other very, very well, is we are an ALM award-winning virtual jury research company. Yeah, we were doing it bricks and mortar before, but we were also, before everybody else, doing virtual mock trials back in 2008. And we really perfected the art of doing virtual jury research. And obviously now that's the majority of all the research that's taking place today. I know that, Dana, we've done a bunch of virtual mock trials with you pre-COVID, and we'll do it with you during the COVID, and we look forward to getting together with you in person once the crisis is over. I will say this about Dana, and Dana, it's not all about you, but I really know you better than Janet and Raul. I just want to say, Dana, the folks at Magna Legal Services, we really appreciate all the support that you've provided to us through the years in supporting our Chop for Chop event, the fundraiser for Children's Hospital of Philadelphia. And I hope that I'm going to see you in June. If everything goes well with the vaccines, maybe with some good luck, we will be together at the Borgata. We'll do another mock trial for Children's Hospital of Philadelphia. And I hope you'll come back up on stage one more time. Not to put you on the spot, but that's what I got to say. So listen, until June, hopefully I'll see you then. I want to pass everybody off to my partner, Mark Calzaretta. He helped me start this company with my partners back in 2007. His head is a little bit shinier than me. Thank you, and I'll see you guys at the end. Thanks.
All right, thank you very much. With that kind of an introduction, now we've got our work cut out for us, don't we? So thank you very much. Thanks for coming. We appreciate it. And I'm looking forward to discussing our topic today, and it's resolving cases virtually. And it's a plaintiff and defense perspective, but we left a little teaser out there. We didn't want to include it. We also have a mediator's perspective here, but we didn't want to spill all the beans. So I wanted to kind of have a little bit left out there. So let me introduce our esteemed, and I do mean esteemed, panel here. And we're very, very lucky to have everyone. First, I want to introduce Janet Rubin Fields. She is our mediator extraordinaire that's on our panel here today. And as you can see, she's in a very serene, nice environment there. She's relaxed. It might as well be a meditator instead of a mediator. You like that? If there was a little bump, Dana, I know you'd appreciate that if we had a little sound effect.
Nice.
We're on a budget. We're on a budget. So anyway, I'm very happy and honored to have Janet. Janet brings with her not only experience as a neutral arbitrator and mediator, but Janet was also a trial attorney representing the serious injury cases in insurance, employment, real estate business, and commercial litigation, really around diverse background. She successfully mediated and arbitrated thousands of civil and commercial disputes, sensitive matters, challenging personalities, and being able to really make people feel comfortable. That's one of the things that reading through her bio and just spending some time with Janet is compassion, empathy, those types of things. I think you'll see that, and that's what makes her such a great mediator, in my humble opinion. But we're real lucky to have her. She's got not only a litigation background, but a mediator's background here. So it's real diverse, and that's going to be. Can't wait to hear her perspective. Raul Ravapindi, and I got that wrong. Ravapuni. Raul, give it to me again.
Ravi Pudi, you got it right.
I got it. I knew I had it, but I messed up. I got nervous. I got choked up there because he's in this beautiful place. Look at where he's living. I wish I was living there. He is a partner at Panache and Boyle, and Raul has spent his career handling catastrophic injury and wrongful death cases involving commercial vehicles, pedestrians, industrial or construction accidents, as well as sexual abuse and sexual assault cases. Him and Dana regularly go at it, so I'm expecting them to have a little bit of fun here today. And as I hear, Raul generally gets a little bit the best of Dana. I don't know. That's what I've been hearing, Dana, but I don't know about that.
Wow.
But he's Raul. We're really lucky to have him. He's the plaintiff's perspective in our of our panel here, and he handles really landmark verdicts. He's got an incredible reputation and background. We're really lucky, and thank you for joining us, Raul, and looking forward to your perspective. Last but not least is my buddy, and he's definitely my buddy. After that, maybe not so much after I just said that about Raul taking him to the cleaners here, but still buddies. And Dana and I have worked extensively together in the past. Dana is a partner at Lewis Brisbois at their Los Angeles office. He's also the co-chair of the general liability practice for Lewis Brisbois. He's nationally recognized as a leading defense trial lawyer. I personally have seen him drop shipped into many cases and take them over and seamlessly. He works on all kinds of high exposure cases, really all across the United States. He's located in California. You might know him. He did have a Dodgers background up, I thought, and you might know him because he was a lead trial counsel for the Los Angeles Dodgers, and Frank McCourt, the highly publicized trial on the assault of the spectator that many of you might remember back at a Dodgers game in 2011. Dana's been named as one of the top 100 lawyers in California by the Los Angeles Daily Journal, and I think he's way up there. I don't think he's in the bottom of that 100. I think he's in that real short list there with Raul. All right, so we're ready to rock here. With that, these are who we have here today, and we're really lucky to have everybody. So what are we going to be talking about, right? We're going to be talking about resolving cases virtually, right, in our new environment. So with that, I think we're here. We're all on Zoom, and with that, what are, there's new challenges, right? Everyone knows about it. We've had some new challenges. People have seen some of these embarrassing moments on Zoom. I think some of you might have seen when a lawyer showed up in her bedroom, turned on her Zoom camera in front of the judge and was in her bathrobe and sitting there about to have a motion. I don't think that's probably the way that anyone would show up to an actual courtroom. So Janet, positives and negatives. Why don't we talk? You must have seen a lot of stuff since April when we were all launched into what Peter was talking about. We're all launched into this opportunity, into this environment where now we got to do everything virtually. So from your perspective, from the mediator's perspective, what have you seen? What are the positives? What are the negatives?
Well, the positives are that most people are coming to the table dedicated. And now that we're in a routine more so than in the beginning. In the beginning, there's the fear factor, change is hard, how we go through the process. We're all reinventing ourselves. And particularly in the legal community, because we never believed we could do this. We never thought of this before. So some of the positives are that people are recognizing and coming from acceptance in getting this done is the Zoom way. People aren't commuting. They don't have the fatigue that they had when they showed up in the morning or when they leave and they go home. They get to spend more time with their families. There's a whole unrelated issue, unrelated and related to not just the mediation, but what goes on in our personal lives. I'm finding that parties are comfortable being in their own homes versus at the antiseptic ADR office, where you are stuck behind a conference room in an unfamiliar environment after commuting a long way, where you can get yourself out the door for using the restroom or eating. I think another positive is that with respect to meeting people, I'm finding on the defense side, the adjusters who might have been by phone and I've only known through a voice, I'm now getting to meet personally. Another one of the positives is that I'm finding people are in a place where whether you're the professional or the personal, that being in your relaxed environment, dressing a little more relaxed can really help in getting into your resolution spirit. On the negative side, I've seen a lot of
negatives. What about the negatives?
I've seen a lot of negative. I've seen behavior that's cowardly, that if lawyers and parties had the courage would never do live. From lawyers opening up alcohol during the middle of the mediation outside the presence of their clients. I've seen them get abusive inappropriately. I've seen them dress inappropriately. And while we're all in a relaxed setting, they forget they have a client on either side of the table that they need to approach. And I think the number one negative would be coming to the table with the idea that they could easily sign out of the Zoom meeting and end it versus investing in the process when you physically have to show up.
Okay. Drinking and Zooming. I don't know if that goes together that well. Maybe
No.
Virtual happy hours, but not a virtual mediations, I would say, right? That's a big takeaway.
Right. And, no one knows what they have in their water bottle or their coffee cup. And I'm referring to actually having the physical alcohol on the table. As well as I had a case where somebody was working out on his treadmill. I want to believe we've all developed that time to do that outside of the mediation, but what messages are you sending to me on how you are present and mindful in getting a case resolved? No different and then we have on the negatives, all the distractions. I'll be right back. I got to take this call. Texting while we're trying to engage in conversation, and easily, signing off to go take care of something else personally or otherwise we're in the thick of negotiation.
Raul, from a plaintiff's perspective, what's your experience been with resolving cases, mediation, virtual mediations? In this, I would imagine you're not just sitting still there, right? You got to move the cases along, right? So what's your perspective?
Yeah, no, actually, through the passage of time, March wasn't that great because, as Janet mentioned, everybody was still in a reaction and how do we adapt stage of the pandemic and virtual mediations and the concepts. But once we started getting things rolling, I've actually had some really good experiences doing everything remotely. Some of the things that we've done, and I think part of it is laying the groundwork, because it is definitely a different dynamic. And if you walk into a Zoom mediation cold, meaning that there's nothing that happened from the day you scheduled that mediation, or even before scheduling the mediation up until the day of the mediation, I could see a lot of opportunities for it to be an unproductive day. But some of the things that have happened and a lot of the mediators have employed, and some of them the parties have employed, have led to really productive mediations. And that doesn't mean every case settles, but nobody left those mediations, even the ones that didn't settle, thinking that they were deceived, duped, or the other side was acting in bad faith. Some of the things like pre-mediation meetings. So a week or two before the mediation, some of the mediators will actually have a meeting with both parties separately so that they actually start that process before the day of the mediation. And that was obviously done before in live mediations, but it seems to be happening a lot more now. And then what that allows is for the mediator to identify where the rubber is going to hit the road on the substantive issues, and allows for the parties to address those issues so that the day of the mediation is actually productive. One of the things that's important to me on my side is that we actually have the decision makers virtually physically present, meaning that the carriers and the people with authority, and like Janet said, this is one of the pluses, she actually gets to meet these people, but having a mediation where the decision makers aren't even there is a non-starter. So that's some legwork on the front end to ensure with opposing counsel that that's going to happen, and that does happen. I can appreciate Janet's comment that, being at home, there are pluses and minuses to that. One of the pluses is that it is a more comfortable environment. I think the offices over at Judicate West are fantastic, and you serve hot lunches. I don't really like cold food, so that's really nice, Janet. But I still like eating at home and home cooked food. So some of those things are positive, but some of the other things are multitasking that, as long as they don't impede with the process of the mediation, allow me to be less frustrated, and my clients, while I like sitting in the same room with them for as long as I can, sometimes there's a little too much downtime in live mediations, and everybody gets a little bit of space to do what they need to do. So I actually like those concepts of it. But the last thing is that I actually spend a lot of time with the opposing counsel before the mediation, probably more so now than I've ever done before, so that when we actually go into these mediations, everybody has hopefully a better idea of what the position is of the other side and what the expectations are from my side. So when we put all of those things into play, there's a whole lot more happening before we even show up to this Zoom mediation that makes it a lot more productive and a positive for me. There is one thing I wanted to share, though. I can show you a negative, and this happened yesterday. Yesterday, and I'm a firm believer. I'm sorry I'm not wearing a tie today, but I'm a firm believer in dressing the part. And so I prefer that people actually dress up for the occasion. And I don't know if I'm able to share. Can you stop sharing for a second, Mark? You're going to love this. So I was in court yesterday, virtual appearance in LA Superior Court, and one of the lawyers appeared, and he appeared looking like this. That's a little tan there, a little shirtless. He stood up so I would confirm that he was in fact shirtless. And I would say that falls into Janet's example of, a bathrobe and not dressing the part. But then at some point in time, I think somebody told him that he was shirtless. It took about 5 to 10 minutes. And then all of a sudden, instead of turning off his video camera, a blue covering went over the screen. So it just looked blue. I'm pretty sure it was his shirt because he wasn't wearing it. And he just kind of used it as a blocking device for the camera. But that is definitely not the way to create the impression that you're actually taking the remote process seriously. So
I would definitely agree with that. And I don't think that's the way to win friends and influence people in any way if you're there to do that. So I think I'm 100% on board with you. So Dana, a little bit of your perspective now that you've seen that, and I'm not sure whether you feel all right after seeing that or not, but maybe you can still talk right after seeing that.
Can't get that out of my eyes. That's going to hurt for a while. So let me before I dive in, let me say something about Peter, who is you all saw as the fastest talking human being on the planet. It's unbelievable how much ground he covered in 4 minutes. But I will say this, and this is not just because Mark and Peter are here. I have gotten to know these guys, and their game is very strong. And I'll just pick on one thing, Mark, that Peter raised, which is the mock trial work that I've done with Magna has been superb. I'm very demanding, and I only have a few mock trial companies that I think really do an excellent job in the setup, the delivery, and the analysis, and Magna's one of them. And Mark, stop listening for a second, but Mark is probably the top of the game. Mark is excellent, and Mark has worked with me on how to develop themes, how to test themes, how to develop a message that may be difficult at times to put out there to a jury, and how to put it in the best way, not spin it, it's not spin. It's how do you deliver a message without offending and with getting your point across. And so if you've got a mock trial coming up, or you have never used Magna, I would tell you, take them out for a test drive on a mock trial. You will not be disappointed.
Thank you.
So, and I'm not paid for that. So that was legit. So let me dive in. I'm going to start with the negatives, but the good news is I think there are ways to deal with the negatives. My first 3 negatives all come under the heading of it's personal contact. As human beings, most of us thrive with personal contact. We are persons, most of us in this business. There are the exceptions. But when you take us away from personal contact, that's a negative. And we have to figure out how to work around it. For example, if I've got a case with Rahul, and he's got a wonderful client, or a severely injured client, or some grieving parents, I know Rahul is going to let me meet them or meet the plaintiff, and he's going to want my general counsel for my client, or my risk manager, or the claims person to meet them too. And that's important. And to establish that human connection, we may be disagreeing on liability, but we can all be human beings together and just say hello, so that when we break up for the next 8 hours, Rahul's client realizes we're human beings too. We may not agree, but we're nice people who are not there to be cold and mean and rude. And I think we just don't have that contact. The second one is, there's a reason I hired Janet Fields. She's really good at connecting with the plaintiff. If I've got a grieving widow or somebody on the other side, if it's a worker who's been seriously injured, Janet can go in and maybe listen, let people dump on her, be cathartic, be understanding, and develop a rapport that then helps Rahul and I, or whoever it is, resolve these cases. And we don't have that right now. And the other one is, I get along with almost every plaintiff lawyer, not all, but we can always communicate. And how many times, I can't tell you the number of times, Rahul Ravipudi or somebody said, Dana, meet me in room 5. I got to explain something to you. And Janet and Rahul or whoever it is, and we go meet in room 5. It's like, Dana, here's what you don't know, and here's what I got to figure out. And we work together. And we don't have that meet me in room 5 thing. Now, there's a work around for all of that. On the first one, if I need my people to meet Rahul's clients, we can set that up in advance. I just call Rahul and say, can we have a Zoom where my people can meet your people? I'm not going to ask any questions. Let's just talk. The second one is Janet can go meet with Rahul's clients. I'm totally okay with that. I think the mediator ethically has to let me know that, but I'm all in favor. If she wants to go spend a half an hour listening to them, talking to them, getting to know them and develop a rapport, I'm great with that. I know Janet's going to stay objective. I don't have to worry about that. And on the personal contact, I agree with Rahul. He and I have talked a lot in advance of mediations. What do you need? What do I need? How to work this out. And then during the mediation, Janet can take us into a separate virtual room. She can set up that room 5 and we can go talk separately and have a dialogue. So you've got to be prepared on those. I think the last negative is a lot of people think there's going to be a second or a third mediation. And they think this is so easy, we'll just set one up. And people come not prepared to really dive into this one, assuming this is the only one. And you should come to this mediation and not assume there's going to be a follow-up. And I say that to both sides equally. You should be ready to go at this mediation, ready to resolve it at this mediation. And I'll finish with this. There are positives. There are a lot of them. I think everyone's a little more relaxed. I think people are not stressed out about running to catch their flights, at the end of the day and stressed out and having to take a red eye. I used to have some East Coast people say, please don't do a mediation on a Monday or a Friday, because then I have to be away from my family on Sunday or Saturday. We've eliminated that. And I think it's easier, as Rahul said, to get the decision makers there because they can do it from home office, or headquarters.
So I'd like to elaborate on some of the points that have been made by both of you, which is that probably number one is on the, can you do a sidebar and, grab the mediator and all those things, which Rahul and Dana and I have done many times because of the professionalism and the friendships. And I think that you can coordinate this. I've done it plenty, whether it's a separate breakout room, whether we talk on the phone, whether we have a pre-mediation conference, however you want to work it. Your mediator, it's really important right now more than ever to be on top of these things. Your mediator needs to be on top of these things. We're all reinventing, we're all reevaluating, including me, which I'm now doing probably more than I have in my profession in a long time, in making sure I can get this the sanctity of the process to remain. You mentioned about how you handle pre-mediation, and I know we're going to talk about that more in conferences. I actually just had a 6-day case, and in those 6 days, sporadically over a few weeks, we took Saturday mornings for me just to meet the claimants with defense counsel's knowledge so that we could. Efficiency has been a positive in Zoom from my perspective. Whether it's how quickly you negotiate or not, it's bigger than that. It's about what we can do with the time that we have and how to make it work. Because while we're in a 24/7 rule, yes, we need our boundaries, but we created these Saturday mornings to meet and greet with the clients so that we could use the negotiation time more effectively, and the clients could be, now that they've met me, be in the background and get the calls when they needed them from their counsel. The other thing is you can have that empathy in sensitive issues come through the camera. I didn't think it could happen. It took me a few weeks to get convinced. A lot of cases, sexual abuse cases, sexual assault cases, wrongful death cases, anything with an emotional component, that you all need your mediator to be there to listen. It's how we can make that that screen disappear while I'm talking with that party to let them know I'm here, I'm listening, my eyes and ears are there. And that sets the table for your successful resolution. And it's just a question of making it happen. I didn't know that it could be done. Some of these cases took a while to get there, but it is happening now.
Right, so touching on that, I mean, I think change, right? Part of what you guys were touching on is that human nature, right? Change is tough. Like going back to the beginning, it was pretty difficult. I mean, I know on our end, we heard, and I've from discussions with all of you that, hey, this won't work. We can't do it this way. We're so used to setting our ways, right? So we heard about the solutions. I think there was a lot of solutions brought up already. But what about like touching a little bit more on like working the room? I think you guys touched on that a little bit, but Raul, what about you, like working that virtual space? What have you found to be effective? And then, let maybe Dana, then we could hear what some of the things some of the techniques you've used. You touched on some. We are going to go into all types of pre-mediation and what we need to do ahead of time. But how have you worked that virtual room?
So one of the things, and in working with Dana a lot, he knows this well, as does Janet. I'm a big fan of technology. And so whether it's doing opening statements or whether it's communicating with others or presenting for CLEs or in mediations, in this remote setting for mediations, this allows actually a lot more utilization of technology. So part of working the room that at least is available even more so now than when you're in person is fielding the questions of the mediator or the questions of opposing counsel that are relayed through the mediator, and actually having my whole body of evidence, my digital file cabinet right there at my fingertips. And whether it's videos, whether it's MRI images, whether it's deposition testimony, whether I have it all prepared or if I need to address it right there on the stand, I can share my screen and I can put up the responses so that the evidence actually does a lot of the talking for me rather than me arguing it and saying, this is how, there's a couple documents over here that say this, and hey, mediator, I know you didn't want too big of a file, so I gave you a short brief, but if you want, I can email you some documents. Let's just have that discussion right here, right now. And that shows two things. One, I'm actually putting it all in front of everybody so they can see it with their eyes. But hopefully a secondary thing, and this is to Dana's point, is that it shows the mediator and everybody there that I'm prepared to have this full discussion and that we're not coming in here just seeing how it goes and flying by the seat of our pants, but we're actually ready to have a discussion on anything and everything related to the case because I'm that familiar with it. So when we talk about the day of working of the room, I think that's a really important thing to do. The workarounds that Dana talked about are, I don't want to say that they are as good as obviously being in room number 5 together face-to-face, but they are really good workarounds. And then the last thing is, even if those workarounds don't work, I know where Dana lives. And I can just walk right over to his house and then we can have that conversation face to face.
True.
In fact, if everybody on this, all 157 participants want to know where Dana lives, stick around at the end. I'm going to post up personal information.
Oh, dear Lord.
All right. So from your perspective, Mr. Defense Attorney, what's your, and not just from, really, that's a joke, right? But from your perspective, not just a defense, what work in the room? You're really, I mean, one of the things, and you can tell, I think all the panelists can tell already, it's just all of the panelists' abilities to connect, right? Even in this setting already, you can feel that. Janet, Raul, Dana, and in person, Dana, I've been with you in court, right? I've been with you throughout all over the country, and I've seen you connect. But now we're virtual, so how has that changed and work in that room? How are you working the room and feeling like you're getting the same effect that you've been getting when you're in person?
So when we say working the room, it's a little unclear because there's actually 3 rooms. So the first room that I'm working with is my client, my decision makers, my people. What?
All the rooms. You work
What?
every.
Sorry, be quiet, Mark. I'm on a roll. So
I thought that was my job.
in my room, in my room with my decision makers, my role is to educate and inform my clients and give them an honest evaluation of the strengths, the weaknesses, and how I think this case will play out. Once I have educated my group, it's people smarter than me and people who have the money who have the right to make that decision. That's not my decision. Once I've teed that up for my client, they get to decide what they want to pay or not want to pay. I should not, Mark, to answer your question, I should not have to work my room on the day of the mediation because I should have done my homework. I should have had my evaluation done. I should have had conference calls in advance. I should have answered the questions. Maybe not, maybe some will come up on the day of, I get it. But if I've got an excess carrier and a general counsel and a risk manager there, they should know all of the answers to the important questions before I get there. There should be no surprises. What does that mean? I've not only evaluated it, I've given them the answers. I have spoken to my opponent. I have asked them for the missing documents. I have asked them for the things that my decision makers need. That's my job. So on the day of the mediation, I should not have to work my room. And by the way, my little footnote here is to the plaintiff lawyers out there, don't drop big, important documents on me within a week of the mediation. It doesn't do me any good. I got to have them 4 weeks before. If you're going to hand me a life care plan the night before, it's worthless. It's worthless at the mediation. There's nothing I can do with it. I need it 4 weeks in advance so that I can read it, talk to my experts, get the experts' input, put something in writing and send it to the decision makers. They then have to chew on it. And by the way, for those of you who don't know, excess carriers don't make decisions overnight. They have to look at it, analyze it. There are reserves. There are chains of command. They need to have the opportunity to make an informed decision. So don't drop important stuff on us at the last minute. And vice versa. You don't want surprises from us either. I then have to educate Janet, Mark. I'm not going to work her, but I'm going to educate her and honestly tell her strengths and weaknesses. Janet, I can't tell you how many times you have called me up on a Saturday and said, okay, I got your brief, I read it. What else do I need to know? It's a great question. Read between the lines. What do I need to know? Personalities, history between the clients. What is it that you can't put in writing that I need to know? And more often than not, her antenna's up and she's right. And there's something there. And then work the room, with a Rahul Ravipudi. I don't have to work them. We've already had our talks, but I've got to be able to get fair numbers out there that make it really hard for Rahul's client to say no at the end of the day. And that's his job to me too. He's got to make it super hard for my folks to say no. And that's our jobs.
All right, so that leads us into I think Janet would lead us right into our next topic, which is the do's and don'ts of pre-mediation, right? And we kind of touched on, I think Dana's already kind of led us into from don't hide the ball, right, Dana? If that's the takeaway from what I just heard, and even from hearing from Rahul, it's don't hide the ball, share the information, get me what I need, be able to show and exchange the information. And cooperation, though, Janet, from your perspective, and what I'm hearing a lot of is the cooperation, right? That there needs to be a cooperative environment, not just from your perspective, but amongst the attorneys and everyone working together. So what's your perspective on that based on what Dana and Rahul said already?
So my mantra these days are, you know what, people, we got enough going on, and let's put down the bravado. Let's be professional. Let's look out for the best interests of everyone concerned in the case, and put yourself out there and the case out there so we can have open discussions to get this resolved. I can tell you that I'm having pre-mediation conferences now on all my full day matters, because I want to know, number one, is the case ready? Because if that life care plan isn't showing up that needs to be there, are we ready to go? And have the parties have enough time to evaluate? Do the principals know what needs to be done and everything else that goes along with it? I can tell you that on pre-mediation conferences, I've learned a lot about what is reading the tea leaves. Do we have client control issues? Are they going to be on the Zoom? Because some plaintiffs' lawyers aren't having their clients available on the Zoom. And they're telling me they don't want them on the Zoom, or they don't want them in the beginning. And for me, I want to connect. I want to meet them. I want to have the feedback to give to whoever I need it. Same on the defense side. There's a lot of carriers that are not, their protocol is we will not show our face. We will not show our name. We'll go but with an ID. We won't use Zoom. We'll use one of the other companies, WebEx, pick one, Ring, whatever it is. So all that needs to be addressed in advance, along with probably the number one thing is communication. And the communication is, do we have all each other's email addresses? Do we have all each other's cell phone addresses? If there's a technological issue, which by the way, Rahul, that's the next thing I'm going to talk about, is then, all right, how do we communicate and connect with each other? All this needs to be done before the mediation starts, and it creates cohesiveness and connection for all involved. I think that sometimes we use pre-mediation conferences to work the room. I believe that most of the time it's profitable for the plaintiff to communicate a pre-mediation demand in enough time for the defense to evaluate, rather than all of a sudden create a surprise or shock value, or I'm falling out of my chair kind of an attitude. That's not going to serve anybody well. And sometimes we get an offer, sometimes we don't. But the most important thing is just get everything ready to go so we can keep with efficiency. On a side note, I'm the positive on technology with Zoom and putting things on in front of me, and the clarity that we get and the ability to have it all right here. This mediator loves show and tell, if I have to see something through a microscope, show me. If you can create your case visually, it has incredible impact on how that jury may perceive it, or how your mediator may perceive it. And both of these guys, Rahul and Dana, are great at that. So sometimes I get to look at those things pre-mediation, sometimes I don't, it doesn't matter, but I wanted to comment on that. The other thing is, we all wear many hats. So when you have parties who are strangers to this process, not the lawyers, not the claims people, it can be invaluable my number one thing is to make them feel comfortable. So sometimes we can do that at a pre-mediation conference versus at the inception of a mediation. So I've been using it for that as well, along with the meet and greets separate from the negotiations.
Can I jump in, Mark, on one thing so we can have a free, and I agree with everything Janet said. There's one downside I just want to mention about getting a pre-mediation demand. My rule is mediate at the mediation. There's a reason Rahul and I hire someone like Janet Fields, because she's good at what she does, and let her do it. I've seen lawyers just lose their what, because someone makes a demand, the other side takes it personally, and everyone gets all pissed off. And now you've got either no mediation, it's canceled, or there's bad blood. I've had clients have very adverse reactions, and I've had to pull them off the ceiling. And so there's a risk if someone makes a ridiculous demand and they're trying to message or do something, that I can lose my clients on my end. That's the problem. I can lose the willingness to mediate, and people just say, forget it. Now, what I would typically say if we walk into a mediation and the demand was unreasonably high, which is 82.3% of my mediations, I just checked statistically, I tell my clients, ignore that. It's just a demand. You're going to pay what you're going to pay. Let's see what happens. And then I say, make Janet work. Let's make her work. So I'm always cautious. And by the way, Janet, I'll get some clients say, go call Raul and find out what his demand is, because we're not going to mediate unless he has a reasonable demand. Well, I guarantee you, Raul is always unreasonable. It's going to be an unreasonable demand. But when we beat the crap out of him through Janet, he'll get more reasonable. Just be patient.
So on that though, I'd say that the rule should be that there are no rules, because there are times where I won't go to a mediation until I get an offer, and the other side says, well, I need a demand. I said, for this case, it's not going to work that way. And then we end up in a mediation where the first thing that happens before that was an offer. There's other times where there just needs to be that representation and belief for my client, for my co-counsel, for myself, that this mediation is going to go in the direction where I thought it would go. And so there has to be that pre-mediation offer. And then there's a lot of times where neither of those things are required. But I think some of the variables can be who you're dealing with on the other side too. So, the dialogue and the trust of good faith between Dana and me is good. So a lot of times we don't have to deal with any of these issues. If it were a stranger on the other side, or a lawyer who has a bad reputation among the plaintiff bar, or even maybe among the defense bar too, then it's going to be a whole different set of circumstances. So at least for me, I need to know my audience before I set down what the rules of the road are going to be leading up to that mediation.
So I say every day, it's a blank canvas, and how's the picture going to be painted? Because every case is unique. And it's about who's in the room, not just about that. You're going to get the same case, same facts, same arguments with different people, and it's going to play out differently. Or as Rahul said the other day, it's the snowflake. And when you treat it like that, you are doing such a great service to your clients, the case, and how we managed to get this resolved.
So those are all kind of pulling it full circle. It kind of leads us, and maybe you guys, I know we didn't have an outline, we didn't have anything, we're just winging it, but you guys are just moving along. You're making this so easy. We're just flowing here. And that brings, at least for me, since I put something together, to really the part that I've been waiting for the whole time. And we touched on it, right? This is the show me the money phase. We touched on it a little bit. But for all of you, one of my favorite scenes from any movie whatsoever is Jerry Maguire.
Show me the money! That's it, brother, but you got to yell that shit! Show me the money! I need to feel you, Jerry! Show me the money! Jerry, you better yell! Show me the money!
So Raul, show me the money, man. That's what you should be saying to Foxy over here. That's what you should be always saying. But let's talk about something. Everyone's heard about this, right? And I'm thinking the answer is, at least from your perspective, is false. But I want to see, is it true or is it false? And I think the rest of our participants would like to know, is that this COVID discount? I mean, this has been something that you've seen around, you've heard it. It's sort of this perception, if you will. From your perspective, is it true or false? Is there any COVID discount?
That's a great question. And if we were in a legal setting, I think the overly broad objection would be sustained right now. But let me try to break this down a little bit. To answer your question directly, Mark, I would say it's false on any of my cases, but I do deal with a lot of high exposure cases, and I'm an incredibly patient person. So if there is a threat of a COVID discount, which there is, then I won't mediate the case. And so if there is an expectation, hey, you want to get this case done, but you're going to have to take a discount, thanks, but no thanks. I do think, and it wouldn't surprise me, that there are certain cases or certain situations and certain clients where the pandemic has created issues that were unforeseen before, and they may be willing to resolve their cases at a discount. So I think in the grand scheme of things, I think there may be some truth to that. But in a micro setting of the cases that I've been dealing with, I haven't seen it. And the cases that I have resolved, it doesn't, in my opinion, reflect any COVID discount at all.
Janet, what, from your perspective, I mean, you're the mediator, you're the one calling balls and strikes. You got to kind of catch the not so friendly fire coming from both ways, right? So what have you seen, if anything?
I can say this, that sometimes the plaintiff's case isn't worth the kind of money they think it is, and they want to call it a COVID discount, and it's not. I've settled cases from 18,000 to 18 million since March. So it depends on a lot of factors. I have seen where the defense has attempted to settle a case less than I've seen the value, but it's a small percentage. And I believe it's within a certain range level of what those case values may be. Certainly not when you get into 7 and 8 digits. Not so much. When you're looking at the cases that, and my philosophy every day is, this is a big case to that party, to that plaintiff, okay? And to the defense and how they close their file and what they do. So it's not about the numbers, but there are times when I've seen it, like I said, a small percentage. I don't, and there are lawyers and firms such as Rahul's firm and where they're going to wait it out if they're not getting the kind of money they think they're going to be able to get. And then again, those cases, I've found them to settle at where they're supposed to. I will also add, I've done more mediators proposals probably in the last 6 months than I've done it on an average than I was doing before COVID.
And so mediators proposals, that kind of moves us to another topic. Dana, from your perspective, mediators proposals, that's an interesting, kind of wrinkle. And for those that haven't been kind of involved or had that come up in their negotiations or in their mediations, I mean, how do you feel about them in general?
So I just want to, let me just make 2 comments and I'll go to that, Mark. First of all, if everyone watched that video of Jerry Maguire, did anyone notice the wife in the background is so calm, ignores her husband and was just doing her kitchen work? It's kind of like my household. And on that video, I'm still waiting for Rahul, when I make him an opening settlement offer, to say, "You had me at hello." Another great line from that movie. But and on the COVID discount, Mark, look, let's remember the other side. I've got clients who make widgets. They don't like being in depositions and dealing with lawyers and dealing with mediations and dealing with trials. They want to get back to doing their work. They want to make their widgets. I represent clients who need to see these cases move forward, not lingering around. And when I get ready for a trial, then put it aside, guess what? There's a cost of me getting back up to speed on the case. Mm-hmm. As for insurance carriers, they've got reserves. They don't want these cases sitting around forever. Everyone thinks, some plaintiff lawyers think, oh, the insurance carrier loves this. It's a delay. It's not. They have to hold these reserves and have all these large pending cases sitting open forever and ever, and they'd like to move it. I think there is a discount, Mark, on some cases. On small to medium cases, I think there is. Let's be honest here, everybody. Plaintiff lawyers are getting calls from their clients saying, wait, it's going to be 9 months. It's going to be a year. That's ridiculous. And money today, we all know, is better than money somewhere down the road. So do I think there is on some cases? Yes. It's not, Raul's right. Let's agree there are no rules in this. There's no set cookie cutter. Raul's not going to discount his wrongful death or his quadriplegic case if he's got a great case. He's not. But some small to medium cases may move. Mediators proposals, Mark, here's the short answer, because I know we're going to run out of time here. Yes, I like them, but some people go to them too soon, too early. They should be used judiciously. They should be used later on, once we've flushed out issues, facts, disagreements, we've run some numbers, and we've tried to narrow the gap. And I don't think any good mediator makes a mediator's proposal unless he or she believes there's a 51% chance, or 51% or better chance that it will work, because if a Janet Field makes puts a number out there without Raul being on board or with me, either it creates a problem that now Raul's client wants a big number that I can't get to, or it's too low and my people say yes, and Raul's now got a problem dealing with that and can never get his client that low. It creates some expectation problems if done wrong, but otherwise they can be an effective tool.
Raul,
You know,
what are your feelings? What are your feelings based upon what we've heard? Good, bad?
Yeah, no, I actually, record this moment. I 100% agree with Dana. So,
Yes. One.
there
I
is
guess I'm out of business.
there is a timing component to it, and if the mediator, whoever it is, plays it fast and loose, they're going to have a low success rate on that. And there is some finality to a mediator's proposal. That's the mediator's proposal. That's where that person sees the case should finish. So how does the mediator walk back from that and try to resolve it at a different number later? It just ends the mediation. So it really should be at the end of the mediation. So,
And the end of the mediation is when you're done negotiating, whether you're physically talking to each other or afterwards. Marination, especially now during these Zoom mediations and COVID, is a beautiful thing from my perspective. Everyone has time to reflect. Everyone has time to reevaluate. And I agree, the timing is everything on those things, but I'm finding them to be effective if they're done right.
Well, I see the other bald-headed partner that just popped on the screen. There's only two of us bald guys here. Everyone else seems to have hair. We got the short end of the stick. So I imagine he's not quiet very often. So it's killing him to not talk. So I'm gonna let him
Shining on my head now, Mark. I'm shining it up. Shining it up. Hey guys, thanks. I like to think of myself as Mark's better half, but I thought this was a great topic. It was a really great webinar. Some good questions. Raul, it was a pleasure to meet you. Janet, if I ever get in trouble, I'm definitely going to, first I'm going to call Dana, then I'm going to call you. And if I have a problem, Raul, I'm going to call you too. I just have one observation or something I want to share with everybody, just in case you don't know that was left out on the COVID discounts. Guess what? At Magna Legal Services, we've got COVID discounts going on right now. That's right, Raul. You probably haven't tried our services yet, but our virtual depositions are discounted so heavily, they're free. You don't even have to pay for the virtual platform. And guess what? We monitor that deposition from the moment it starts until it ends. There's somebody actually watching it to make sure that it goes properly. And secondly, if you have an issue, we have live tech support. So all those other carriers or providers that are not doing that, guess what? We're actually watching, paying attention, and we'll teach you or your assistant on how to present and mark up and share exhibits. So we've got it going on, and I've got all kinds of other crazy discounts, but I promised Dana that I wouldn't get cheesy. So I'll just give you my number. It's 866-624-6221. Don't forget it. Don't forget Raul. Don't forget Janet. Don't forget Dana. And don't forget my partner, the brains of the operation, Mark Calzaretta. Thank you, everybody.
thanks for having me.
Thank you. Great job,
Thank
guys.
you so much
Stay
for
well.
the opportunity.
Thank you. Hey, Dana, we'll see you in Borgata in June at Chop for Chop.